Hi there, I'm Clifford Bates, and welcome once again to reading Carl Schmitt's Dictatorship. Today we're on the we're continuing chapter 6 of Dictatorship. This is the fourth part of the. I divided chapter 6 of Schmitt's Dictatorship, the state of siege, into 5 sections. This is the fourth section, which is between in the Polity translation, the Polity published translation in English, pages 167 to 173. So it's continuing the question of the state of siege again, and the question of the commissarial dictatorship. Let's just try to do this. We'll take off where we left off. We left off right here, as you can see, talking about how the question of constitutional liberties, particularly the free, that all of a sudden the change of the situation of the claim of the state of emergency or the state of a state of siege or the state of situation that was originally situationally dependent now became a political decision aimed at the people within their own thing, right? And therefore the state of what he says the kind of suspension of the Constitution. Okay, and therefore this was the question here of he says now is linked to the fight for constitutional guarantees, in particular for personal freedom and for the freedom of the press. That's where it left off last week. When we looked at it on the previous day, last video that we had. Now we're continuing. Given the exceptional law that dealt with the state of emergency, these liberties stood vis-a-vis the problem of sovereignty, and analogically, analogous, with the question of vested rights in constitutional corporatism. Okay, this is a very German law conception that the vested rights, he says, Wohen Verben, in constitutional corporatism, that is the Standstick Riksstaat. Okay, the right state. This idea, therefore, the rights in other words, the question of, in other words, what rights do you have? What vested rights a citizen has into this corporate constitutionalism in that sense? He says all parties agreed without hesitation that the exercise of sovereignty was tied to spheres of authority regulated by laws. Okay, so therefore, in other words, everyone is agreed, all parties agreed that sovereignty and the exercise of sovereignty was tied to spheres of authority that were regulated. But the questions of them, he says, the jura extraordinary matis or jura dominatus. You go see page. So hold on. This is go back to the beginning of the thing. So let's get this. The extraordinary of the magistrate power, state power, right? And the rights of domination. Okay. He says that the questions of the supreme magistrated power, the power of majesty, and rights, which we talked about at the very beginning, in chapter 1 of the book, when he talked about going back to the feudal times and time of the church, right? He says it returned in a different form. So therefore, these two concepts, the extraordinary majesty, the rights of extraordinary majesty, and the rights of domination, it has come back, but in a different form, by deploying the same distinction between what was legally regulated and what is a limited exercise of sovereignty, and the substance always remaining hidden but at hand, and in principle unlimited, of the omnipotence of the state, which penetrated the system of spheres of authority, owing to a specific state of affairs measured by criteria of instrumental efficiency. In other words, so that's saying this is like big sentence. He says that they agree, in other words, the question of these two concepts of the extraordinary majesty and the right of domination, domination in a sense. These return, but in a different form. He says by deploying the same distinction between these two, right? And what is that? Which between what is legally regulated, that is, what is limited, what is a limited exercise of authority, and the substance, always remaining still at hand. That's it. In other words, what is something regulated and what is something completely unregulated, limited, unlimited, and unregulated. Or in other words, he's saying these two things. That is limited exercise of sovereignty and the substance always remaining hidden but at hand, and in principle unlimited of the omnipotence of the state. So the omnipotence of the state is there, which penetrates this whole system of spheres of authority, owing to the specific state of affairs, the situation you're in, by a criteria of instrumental efficiency. The royal government, regulated by Article 14 of the Constitution of 14 June 1814, as the legal basis for all extraordinary authorization. In other words, the royal government regarded Article 14 of this 14th Constitution, the July 14th Constitution, June 14th Constitution, June 14, 1814, as the legal basis for all extraordinary. So this Article 14. This article specified under the heading forms of government of the king, the kinds of government exercised by the king, the forms of government of the king. So that's the French, literally. Forms du government du roi. So the kinds of government exercised by the king, that the king was the head of state, and the military power under his command declared war and made peace, appointed officials, and made all the provisions needed for implementing the laws and security of the state. The royal government saw it perhaps not as a commissarial authorization in case of emergency, as much as an expression of its own sovereignty. In other words, the king understood not as a commissarial authority, this in that article, to declare this in question like this, the question of the state of emergency and the crisis, but rather of its own sovereignty. This is why it was not perceived to be unconstitutional, even when it gave orders that violated the existing law in the Constitution itself, provided that in the king's judgment, these orders were necessary for the safe preservation of the existing order. In the political terminology of the day, this was a dictatorship. He says was a dictatur was a dictatur in the French, dictatorship. In truth, the truth is that it was neither a commissarial nor a sovereign dictatorship. Again, back to this concept. Commissarial dictatorship is a dictatorship established by the laws, or it is that of exercising authority of the sovereign, extreme power, and has authorized it to this. This is the classic example from the Roman example in that sense, the commissarial dictator. But a sovereign dictator is the one who is the sovereign who exercised the power of the sovereign itself. It is not a commissary. It is the body that decides in that sense. So, in truth, is that this power out of article, the article wasn't neither a commissarial dictator or a sovereign. It was simply the pretension of sovereignty as a form of authority, in principle unlimited, in a state whose commitment through extraordinary language only held for situations considered to be normal. From the perspective of constitutional law, the monarchic principle, which could, the monarchical principle, which could adapt so many and diverse political and theoretical constitutional meanings, denoted a let's look at this. Denoted a what? Donated a. So diverse political and theoretical constitutional meaning denoted a distinction between the sovereign functions of an extraordinary and an ordinary and extraordinary type. So therefore, it distinguishes between an ordinary type of sovereignty and the extraordinary type, he's saying. Look at footnote 36. On the occasional meeting between Rouge and this, and Wolfowitz of that article, right? Kurt Wolfowitz made a statement concerning the systemic and methodological contradiction between a state theoretical construct and political ideas. So there's a distinction between this in his essay, State Theoretical Forum for Political Idea and Political Ideas. His comments are of fundamental significance, although they're limited to a sketch, as was appropriate for the occasion. So he points to that little example as a point here. Okay, let's go back. The first captured through legal regulation, and hence they were subordinated to it. The latter were the direct expressions of the unlimited potential of the plenitude of powers, the plenitude of powers of a sovereign, in that sense, of the ruler of the sovereign entity. So, so the first conception of it, right? Only a literature that has lost any sense of the fundamental juridical problems of political science. In other words, only a literature that has lost any sense of the fundamental juridical problems of political science. That is, the opposition between right and the exercise of right, can detect here in distinction between the substance of sovereignty and its exercise, a minor scholarly subtlety. So therefore, he's saying that what is only literature, in other words, he's criticizing the literature of political science, right? That, in other words, has lost the understanding of the fundamental problem of a right and the exercise of a right. Can detect here a distinction between the substance of sovereignty and its exercise, only a minor scholarly thing. If sovereignty is indeed omnipotent, omnipotence of the state, and if this is true for any constitution that does not separate or completely distinguish between powers, then the legal regulation inevitably captures the predictable content of the execution, but never the substance of the fullness of the force itself. So as he says, therefore, in other words, if sovereignty is indeed the omnipotent of the state, right? And this is true for any constitution that does not separate or completely distinguish between powers, then the legal regulation inevitably captures the predictable content, the question of what is execution of this power, but never the fullness of the force itself, the sovereign force itself. They say the question of who decides on it, that is on the case that is not regulated by law, is at the heart of the question of sovereignty. So who decides it? In other words, who decides what in terms of the case that's not the situation or it's situation in which the case which the normal law won't apply in that sense. That is the question of sovereignty. The monarchies of the Restoration appealed to this notion of sovereignty as an authority and in principle unlimited in order to do what was advisable to keep the state safe, whatever the actual circumstances. They did so without being bothered that the existing regime might oppose such measures. In other words, the new regime, the new political order may not oppose this, but they're going to do whatever. In other words, the monarchy of the Restoration appealed to the notion of sovereignty as authority, and therefore in principle unlimited, in order to keep the safe state, regardless of whether the new regime thought would be bothered by this, right? Thus, they grabbed the power constituent, the constituting power for themselves, instead of seeing themselves as its mandate. In other words, they grabbed the constituting power themselves, the pouvoir constituent themselves, rather than seeing themselves as the mandated actor, right? The mandatee, the person who's mandated to execute that, right? During the discussion of the orders of July 1830, which had been initiated on the strength of disposition and led to the outbreak of the revolution and to the overthrow of the sovereign kingdom. Minister of Justice Chantelouze remarked in his report that Article 14 did not give the king the authority to change the Constitution, but only to secure and protect it against amendments, and that the current situation made the expression of such a supreme power, such pouvoir supreme power necessary. In other words, his job is not to change the Constitution, but to preserve it, and therefore to prevent amendments to it in that sense, right? And therefore, the situation made the expression of such extreme power at the exercise of sovereignty necessary in a sense. But it was immediately obvious that the bearer of a sovereignty, thus understood, could only be interested in maintaining the status quo. So therefore, in other words, his only understanding is to maintain the status quo, not to change it. The report stated further that one was allowed to transgress the legal system in order to preserve the spirit of the Constitution. A pouvoir constituent, in other words, the constituting power that belonged to the king, was opposed to the people, as was also discussed. So therefore, in other words, this idea of the difference between the power of this is that. Okay, note 37. Let's go look at it. The report was published by Jean-Baptiste Honore Configure, which is that, and it says, for the concept of the power constituting, go look at, again, page 72 above. The decree of 26 July 1830, the coup d'etat, ordered restrictions on the freedom of the press, dissolution of the chambers of deputy, and the amendment to suffrage, if these are relevant here. On 27th July, riots broke out in Paris, and the National Guard sided against the king. On July 28, 1830, the city of Paris was for the first time declared to be under siege by royal order and with reference to Article 53, 101, 102, 103 of the decree of 24 December 1811. The justification was the internal riots throughout 27th July that disturbed the tranquility of Paris. Even here, even in the declaration of a state of siege, the military nature of the events was evident. Initially, the suppression of civil liberties was not related to the state of siege, but to the royal orders issued on the basis of Article 14 in the interest of state security. The purpose of the Revolution of 1830 was a constitutional government modeled on the English pattern. Article 14th of 1814, the Charter, right, recurs in the Constitution of 13 August 1830 as Article 13, and in the same form, except that now the king was only supposed to make the arrangements needed for the execution of the laws. It was explicitly added that he himself could never suspend the laws or give a dispensation to their execution. So therefore, he could only exercise the law in that sense. The king could only act as the executioner to arrange these things. That he himself was not going to be the one who explicitly said that he himself could never suspend the laws or give a dispensation to their execution. Excuses. The state of siege is not mentioned in this constitution. It was declared by royal orders as early as June 1832, and it was directed against two movements completely different in their political character, which nevertheless had a common enemy. The liberal bourgeoisie, right? The two movements that happened, their enemies with the bourgeoisie. These movements were the Royalist Rebellion in the Vendée and the Proletarian Uprising in Paris. The bourgeoisie parties back then made no objection to the state of siege. Okay, 38. The mention of antecedent to June 1832 in the King's speech at the opening of Parliament session of 19 November 1832 caused enthusiastic acclamations. The Royalists called the state of siege a government dictatorship. In his speech of 4 January 1849, which was held in the Spanish House of Despoties, Donis Cortes said the dictatorship was struck in Article 14 of the Restoration Charter, in the introduction of the Charter from 1830. And the Republic of 1848 was nothing but a dictatorship in Republican disguise, right? In that sense. A royal order of 1st June 1832 declared these aggrandizements or districts to be under siege. In other words, declared 3 districts, the aggrandizements, to be under siege, on the grounds that it was necessary to suppress the insurgent movement in these areas quickly and by all legal means. The Minister for Domestic Affairs and the Minister of War were entrusted with the execution of the order. The law of 3 June 1832 declared squarely, without any particular justification, that the communities of several provinces were under siege. Let's see what note 40 is. He goes, that's just a reference to the specific thing, okay. The third order of 6 June 1832 declared Paris under siege, but with the added amendment that it could not be found that other orders stating that no changes could be made to the commando and to the service of the National Guards. The raid on public and private property, the killing of members of the National Guard, infantry, and the public officials, and need to maintain public security was by forceful means were mentioned by way of justification. So let's go look at 41, note here under the state of siege. And that's just, again, a specific note to the reference. So we won't talk about it in that sense. At that date, all the civilian authorities retain their functions. But in fact, this was only because the government had ordered it. The instruction that the commander of Paris received from the Minister of War stated that owing to the state of siege, the military commander could exercise all functions of civilian authorities, be they administrative or judicial. However, the intentions of the government was to allow the military justification to step up only in specific instances related to rebellion and certain offenses committed by the press. There was to be no interfering in the business of ordinary authorities. So therefore, there was the idea, even though it didn't say that, he's saying that the situation was designed only for the military affairs, the rioting and the violence, not to, and therefore the government had all the authorities of that civilian authority exercised by the military commanders on those issues, but not ordinary business, right? There was to be no interfering in the business of ordinary authorities. The government endeavored to restrict the state of exception to the rebellion, and none of these citizens not involved in it were to have their general rights and liberties impaired. So if they weren't involved in the rebellion, the citizens were not going to have their rights. The citizens who were not involved in the rebellion were not going to have their normal rights impaired. In the argument here, it says, right? Here, one sees plainly how the instrument of unconditional military action, how the instrument of unconditional military action, the commissariat dictatorship, could become a legal institution regulating the state of siege. So therefore, this commissariat dictatorship thus becomes a legal instrument regulating the state of siege. As fitted the constitutional character of the citizen monarchy, one attempted to restrict the military chief's supreme sphere, not supreme, the restricted military chief's sphere of authority by limiting not just its prerequisites, but also its content. So it's not only in other words, its prerequisites, limiting the powers that came before, or things became before, but also its content, right? No longer could a certain okay, let me just return to this point. I had to stop for a second for this issue. It says no longer could a certain district be placed outside the Constitution, nor could the unlimited power of the state be exercised directly, not even over a limited perimeter of duration. Yet the exercise of a commissarial mandate had the typical effect of eliminating and compressing legal limited duty, thereby impairing, at least in part, the regular separation of duties and the legal protection it offered. So therefore, in other words, a commissarial situation, a mandate to deal with a problem like this, therefore kind of allowed for the exercising of power, more powers than was granted, and also maybe even overriding certain rights, right, and limitations. Now, according to the new state theory, the civil servant had no right, vis-a-vis the state, to exercise his duties and responsibilities, and the citizen had no automatic journalistic entitlement to claim that the sphere of duty, as regulated by law, remained unchallenged. So therefore, the situation, the new theory of state said, well, first of all, civil servant had no right, vis-a-vis the state, to exercise his duties in that sense, and that the citizen had no automatic journalistic entitlement to claim that sphere of duty as a journalist, as regulated by law. In other words, that sphere of duty regulated by law was unchanged. But the most striking disposal of a constitutional right was embodied in another effect: the fact that the citizen's legal protection was impaired when judicial duties were suspended through commissarial actions in summary process, and when legal remedies were abolished Okay, so therefore that's the next thing. This is the state of siege in the situation where this new condition here creates a new situation. He goes, according to Article 53 and 54 of the Constitution of 1830, it was guaranteed, as it had been previous constitutions, that nobody should have his or her natural, in other words, have his her natural judge revoked, and that the extraordinary courts or commissions were not permitted. It said that this constitutionally recognized right to a natural, and that is, in other words, lawful judge, could not be put to sleep with the idea, or rather the poor excuse of one, that the military commission had become a legal judge simply as a result of the state of siege, an idea that rapidly made inroads even at the time. The Court of Appeals was then holding the view that Article 103 of the decree of 24 December 1811 was contravene Article 53 and 54 of the Constitution of 1830. Decision of June 30th, 1802, in the Jeffrey case. Jeffrey was sentenced to death by a military court and subsequently made a plea for a trial in a court of cassation. For other similar decisions, see Trésor de Farge, the state of siege, that he says. In other words, that note. So, a right guaranteed through the Constitution appeared here to the court. So that's classic. Something short. No, something short. Here, so those appears something short as an obstacle, something short of an obstacle, to court as an obstacle to military action. Therefore, it must be of necessity follow that other constitutional rights also oppose military action. Okay, right? In that sense, the National Guard was whose responsibility in 1832. The 1832 declaration of the state of siege in Paris was explicitly protected. Fought with fierce zeal against the rioters of 1832, that is, against the revolutionary proletariat. In June 1848, the same situation arose, the state of siege, declared by the National Assembly of 24 June 1848, aimed to protect private property and the civil constitution. Paris was placed under siege. Moreover, General Conviac was invested with executive authority. This petition had requested that all the powers be passed on to him. It's going to be the 43. It's just the reference, these reference to 47. But a transition of the powers of enforcement was not justified by its restriction to executive functions, in the sense that a military commander had only received the sum of the functions normally given to a civilian authorities, while it was clear beyond a shadow of a doubt that the general had no legislative powers. So therefore, he was only given the executive powers in that sense, not all sovereign power in that sense. In the view of the state of siege and of the powers vested in him as supreme commander of the capital's armed forces, Cariac issued a number of orders banning protest posters that did not come from the government, disarming National Guard who did not respond to the call to defend the republic, executing in court-martial style anyone caught working on the barricades. Such people had to be treated as if they had been caught with a weapon in their hands. Cross-examining persons arrested on account of their involvement in the riots of 23rd June. And this had to be done through the office of the court-martial of the 1st Military Division, who had to report back. and proceedings of all crimes and assaults committed in the area of Paris under the management of military authority. On 28 June, the National Assembly delegated the executive power to Convac under the title of President of the Council of Ministers. He took the government and appointed the ministers. The state of siege was suspended on 19 October 1848 through a resolution of the National Assembly. The events of the year of 1848 led to a legal regulation of the state of siege that marked a final stage of its development. The regulation concerning only the political or so-called fictional state of siege and addressed two questions: the responsibility of its declaration, and together with the conditions that would sacrifice for it, and at the next stage, the content of the authorization granted to the military commander. So therefore, in other words, it dealt with two things, right? The responsibility of his declaration, together with the conditions that would suffice it being declared, and what the content of the authorization granted the power of that. It is immediately obvious that the matter of a provision concerning the sufficient conditions or responsibilities, whether it befell the parliament or the government, failed to touch on the kernel, the heart of the thing itself, which, according to the analysis so far, should be called dictatorship. In other words, it doesn't really hit on the question of dictatorship. The attempt to define the content of powers of the military commander is even more interesting. The law of 9 August 1849 on the state of siege retains the existing regulation for the military state of siege. The real problem with the provision of the political state of siege was perceived to be the suspension of liberties guaranteed by the Constitution. So, in other words, the regular state of siege, or the normal state of siege, that was the military aspect of it was left alone. The real problem was the political state of siege, right? And the suspension of constitutional rights. The law embraced the principle that all citizens, despite the state of siege, retained their constitutional guaranteed rights insofar as the latter were not suspended through a special provision of the law, Article 11. Therefore, the provision had to make sure to list certain rights which were to be suspended at the very moment when the state of siege was declared. In other words, these rights no longer constitute a legal impediment to the concrete measures taken by the leader of the army. Nevertheless, the legal regulation went beyond the simple denial of rights to delimit the leader's power also in the assertive fashion. So therefore, it did two things. Not only it said what rights were going to, in other words, what rights were to be suspended in that situation, but also did what? It delimited the power of the leader's power in an assertive sense. Up to this point, the most controversial question that was that of military jurisdiction. And it was resolved by deciding that the constitutional guarantee of a natural judge could be suspended, right? So that sense. So therefore, that the first thing is jurisdiction, military jurisdiction. That was the most controversial, but it was decided that the constitutional right of this judge be suspended during that situation. At the same time, the void resulting from the suspension was filled by making more detailed provisions concerning the composition of the extraordinary court and their responsibility. So yes, it granted them the suspension of normal judge, but then what it did was it gave more detailed provisions of the composition of this extraordinary court and their responsibilities. Hence, once again, the suspension of a right combined with a positive regulation for the state. So an exact suspension of right, there was a suspension of right, but also a regulation about how that suspension of right was to be done, right? A positive regulation for the state of exception. Likewise, the function of the military leader were listed. These quote, semicolon, undertaking house-to-house searches, banishing suspicious persons, confiscating weapons and ammunition, prohibiting dangerous publications and meetings. So these are the things he could, thus permissible intrusions into personal liberties, into the freedom of the press, into the freedom of assembly, and as far as arms and ammunitions were concerned, into private property, were clearly defined. But the military chief was not allowed to interfere with other civil liberties and civil rights and liberties warranted by the Constitution of 1848, such as private property, freedom of conscience and expression, freedom to work, and the right to ratify taxation. So therefore, it's not a complete, in other words, at the same time, while it says you can do these things, but then you cannot do these things. So we'll stop here. If you have any comment or questions, please put them in the comments below. Again, you can see I'm not that well. I'm still sick a little bit, but I needed to get this done, so otherwise there'll be no video today. So if you have any comments, questions, put them in. I see them, I'll respond to them. If you have like it, hit the like button. Share it with your friends, share it on social media. If you didn't like it, you can say no, but say why in the comments. If you've not subscribed, please subscribe. Encourage others to subscribe. And if if you want to follow me on social media, the links are below. The academic social media links are below. And last but not least, if you want to help me do what I do, you can become a member or subscribe star on Patreon from my account. Or you can buy one of the books, one of my books that are listed below if you don't want to do that. Okay, that's it. Next video will be the last of the Carl Schmitt videos. We'll finish chapter 6 and we'll finish dictatorship. Okay, well, take care and have a good one. Have a good day. Take care. Bye-bye.